Hi, today we discuss about arbitration and its relationship with special legislations which provides their own judicial forum and laws to deal with any kind of disputes. Let's take the main example of the SARFAESI Act, under which it becomes applicable when a property has been mortgaged with any of the financial institutions, say an NBFC or a bank, and in your loan agreement there is also an arbitration agreement which is there. Earlier there was some kind of an understanding perhaps that the bank could, if there was a dispute with you, they could either go for arbitration or they could go for SARFAESI action and go to the debt recovery tribunal. So it was known, idea was the doctrine of election. The person instituting the complaint would have a choice and elect the forum that he will go to. Thereafter, what happened was there were a series of judicial decisions whereby it was said that no, the financial institutions can do both at the same time. Grossly inequitable for the person aggrieved. For the respondent, it would have to go to the arbitration, and then it would again have to also safeguard itself and before the DRT or the DRAT and so on and so. Now, however, the law is completely changed again, which is a problem, continuous change of the law, but it has now changed. There's a judgment of the Supreme Court, Vidya Drolia, which came out in late 2020 and reported in 2021. Now, that says clearly that if there is a special remedy which is provided, like in the case of a property which has been mortgaged with any of the financial institutions, it would be an action under the SARFAESI Act, the Securitisation Act. If that kind of a special remedy is provided for, then there cannot be any arbitration. The financial institution will not even enjoy a right of election of going to arbitration rather than going before the debt recovery tribunal under SARFAESI. No, the court says no, you don't. That is any kind of proceeding before an arbitral tribunal is a nullity. It cannot be done. It can only proceed before the DRT. Now this is significant. This is extremely significant because many of the times when we come across these situations, the financial institutions always proceed in both forums. Go before the SARFAESI as well as go before any arbitral tribunal. Now this is something now as new law which is completely changed. So any action taken by way of arbitration, even if the arbitration has commenced, even if the arbitration has concluded, anything, because the tribunal did not have, please mind you, did not have any kind of subject matter jurisdiction as per the Supreme Court, any award passed by it is barely a nullity. It cannot be enforced. So please keep this in mind, my friends who are facing this problem. And if you have a situation where you are facing an arbitration action or an execution of an arbitral award, along with any kind of action under the SARFAESI, or if your property has been mortgaged and thereafter they have started arbitration action, immediately contact your lawyer, and I'm sure your lawyer would be extremely aware of the Vidya Drolia judgment and contours thereof, and immediately take action to safeguard you from any kind of threat under the Arbitration and Conciliation Act. Hopefully you enjoyed this and this information helps everybody. Thank you. Take care.